Chapter 3. The Failure of Data Security Law. It began with a seemingly small theft. A laptop computer went missing from the Veterans Affairs Medical Center. This theft, however, turned out to be anything but small. An employee had put the personal information of about 7,400 patients on the computer, their names, birth dates, physical description, age, weight, race, and the last 4 digits of their Social Security numbers, among other things. To make matters worse, the information was unencrypted, which meant that the thief could readily access it. Putting unencrypted personal information on a laptop, especially sensitive patient data at a hospital, is a big security no-no. But it happens all the time because people often act carelessly. As is typical procedure following many data breaches, the medical center notified all the patients whose information was on the missing laptop. In every state in the U.S., the law requires that individuals be notified if their personal data is lost, leaked, or improperly accessed. The medical center offered free credit monitoring to all the patients for 1 year. The problem, though, is that credit monitoring for just 1 year doesn't really address all the harm to the patients. Credit monitoring is a service that consumer reporting agencies provide that alerts people if there is unusual activity in their credit report. Credit monitoring doesn't immunize against fraud. It only provides an alert if there is suspicious activity. The period of 1 year is very limited. Criminals can use personal information to conduct fraud at any time, possibly many years in the future. Because credit monitoring sounds protective, it actually risks lulling people into a false sense of security. You can have your identity stolen, your tax refund intercepted, your sensitive information leaked, and your personal hard drive with all your documents and data locked up behind ransomware without credit monitoring triggering an alert. Later, Dorn VAMC officials lost 4 boxes of pathology reports with information on about 2,000 patients. These boxes contained names, Social Security numbers, and medical diagnoses. As with the laptop breach, Dorn VAMC notified the individuals and provided 1 year of free credit monitoring. The credit monitoring here did nothing to rectify the fact that patients' intimate health information was compromised. A group of affected people sued Dorn VAMC. They argued that the breach caused them embarrassment, inconvenience, unfairness, mental distress, and threat of current and future substantial harm from identity theft and other misuse of their personal information. The plaintiffs argued that they had to spend time monitoring their accounts and purchasing various services to protect themselves from potential fraud. Addressing both incidents together, the court noted that the data breaches were disconcerting, but the plaintiffs had not suffered harm. The plaintiffs claimed that the lost data put them at greater risk for future fraud and identity theft. The court concluded, however, that this claim was too speculative because the plaintiffs had not yet been victimized by fraud. The fact that plaintiffs spent money for services to protect themselves was self-imposed, an attempt to manufacture a harm. The plaintiffs were thus out of luck. This case demonstrates how badly the law of data security fails. The law failed to prevent the data breaches, which were readily preventable. The law failed to hold the medical center accountable for its inability to keep the data secure. The law required patients to be notified of the breach, but it failed to protect them from the harm the breach caused. The law also failed to compensate the patients for their lost time, anxiety, the increased risk of fraud they faced, their lost privacy over their personal and health information, and their expenditure of money to protect themselves. In almost every way, the law failed. In this chapter, we examine personal data security law. This relatively new body of law has developed quickly, mostly in the last few decades. It is a sprawling framework involving numerous types of laws at the federal and state levels, as well as internationally. Broadly speaking, there are 3 types of data security laws: breach notification laws, laws that require organizations to notify various government authorities and affected individuals in the event of a data breach. Security safeguard laws, laws that require substantive administrative, physical, and technical measures to secure personal data. And private litigation, lawsuits brought by affected individuals who are harmed by a data breach. Our goal isn't to explore the law in intricate detail. Treatises are written for this purpose. Instead, we aim to show some of the key themes of this law and draw some big-picture conclusions. With data security law, the forest is often ignored for the trees, and laws keep sprouting up based on trendiness rather than good policy. Each type of security law accomplishes some good things, but each type has many weaknesses. We are not arguing that existing security law should be abandoned, nor are we arguing for completely different types of security law. Instead, the shortcomings of these types of law are actually due to a more overarching problem. Data security law has an unhealthy obsession with data breaches. This obsession has, ironically, been the primary reason why the law has failed to stop the deluge of data breaches. The more obsessed with breaches the law has become, the more the law has failed to deal with them. Breach notification laws. In February 2005, people in California started to receive letters from ChoicePoint, a company most had never heard of. ChoicePoint's business involved collecting personal data from numerous sources to compile extensive dossiers on millions of people. Companies and government agencies could sign up to access this data. Among other things, ChoicePoint provided organizations with background check services for use in hiring. It stored the name, address, social security number, driver's license number, credit report, and other information on virtually every adult in the United States. Individuals, however, had no idea that ChoicePoint was gathering and selling all this data about them. ChoicePoint wasn't the only company doing this. In fact, many companies were engaged in this activity, and companies are still doing it today. This type of data aggregation and analytics is now referred to as big data. Back in 2005, the activities of companies such as ChoicePoint weren't well known to most people. The fraudsters in the ChoicePoint breach walked right in the front door. They pretended to be a legitimate business, which signed on as a client. The fraudsters were able to obtain personal data on approximately 162,000 people. The criminals then used the data for identity theft. At least 750 individuals suffered identity theft that was traced back to this breach. By today's standards, this breach was tiny. It pales in comparison to Yahoo's breach of more than 1 billion people, or to other breaches with hundreds of millions of people. Yet, in 2005, when the breach was announced, it was a gargantuan story. At the time, the ACLU stated that the breach may have been the biggest release of personal information to data thieves ever. The story captivated the media. Far from a fleeting headline, the ChoicePoint breach was the story that wouldn't go away. Unlike most news stories in this century, it lingered in the media for months. Why was this breach different? There had been countless other breaches before ChoicePoint, so why all the fuss? The reason was because of a unique and innovative law that California passed in 2003. The law required public and private organizations to notify Californians when the unauthorized acquisition of computerized data compromises personal information maintained by the person or business. The law didn't specify a deadline to notify people. Organizations had to act without undue delay. Prior to the California law, most breaches were dirt swept under the rug. They were certainly occurring, but they were ugly secrets whispered in the corridors. Why would a company publicly announce it had lost control over people's data if it didn't have to? With California's law, for the first time the dirty laundry was starting to be hung out in public. The ChoicePoint breach angered people because it was not just about security. It was also about privacy. A company they hadn't heard of was collecting their data. People were upset they didn't know about it. They were upset because there was no benefit to them by ChoicePoint's collection of their data. All this was on top of the fact that the breach led to their data being in the hands of fraudsters. People were outraged. ChoicePoint sent the initial breach notification letter just to the 35,000 California residents who were affected. Only California residents had been notified because California was the only state that required it. Soon after, the attorneys general from 19 other states began to clamor for their citizens to also be notified. They sent a letter to ChoicePoint demanding that every victim be notified. Facing increasing criticism, ChoicePoint notified all affected individuals. In the month following the disclosure of the ChoicePoint breach, 4 major companies disclosed data breaches, including Bank of America. The dramatic rise of breach notification laws. Breach notification has been the fastest-growing and trendiest type of data security law. These laws continue to spread around the world. The laws have been evolving to include more types of personal data and to shorten the time organizations have to report data breaches and notify affected individuals. Soon after the ChoicePoint breach notification laws started sprouting up in other states. Every state wanted in on the action. By the end of 2005, 20 states and Puerto Rico had passed their own data breach laws, modeled largely on California's law. By the end of 2006, more states passed data breach notification legislation, bringing the total to 33 states. By the end of 2008, all but 6 states had passed data breach notification laws, with the rest gradually adopting laws at the rate of approximately 1 per year. In 2018, Alabama and South Dakota became the last 2 states to pass breach notification laws. Thus, within the span of 15 years, all 50 states, the District of Columbia, Guam, Puerto Rico, and the Virgin Islands passed breach notification laws. This is truly a remarkable development. It is rare that all states reach a consensus about the need for a particular type of law, and it is quite amazing that they all managed to pass legislation in such a short span of time. At the federal level, there was considerable talk about passing a breach notification law, but Congress has been gridlocked in partisan bickering for much of the time since 2000. During a brief window of legislative activity when the Democrats controlled both houses of Congress in 2009, a breach notification requirement was passed as part of the High-Tech Act, which was part of the law known as Obamacare. The U.S. Department of Health and Human Services, pursuant to the High-Tech Act, promulgated the HIPAA breach notification rule on January 25, 2013. This was the first federal breach notification requirement, though it only applied to health data regulated by HIPAA. Had Congress not been so broken in the early 21st century, it likely would have passed a broader federal breach notification law. Breach notification also has proven to be quite popular abroad. Unlike many types of U.S. privacy and security laws, which are viewed by much of the world as weak and incoherent, countries have eagerly sought to emulate the United States in breach notification. The EU incorporated breach notification as part of its major privacy legislation. The General Data Protection Regulation, GDPR. Breach notification has been a huge hit. Mandated disclosure laws like this one are popular, at least in part, because they don't eat up a lot of resources for enforcement, and they relieve lawmakers from making some difficult case-by-case decisions. You have probably received quite a few data breach notification letters. If you haven't, then you might want to call the Guinness Book of World Records for being the only human alive not to have received a breach letter. In case you haven't received such a letter, or more likely haven't read any of these letters, here's a brief overview of what the typical letter says. It begins by saying that the organization regrets to inform you that your data was lost or stolen or improperly accessed, describes the type of data involved, briefly relays what is known about the incident, provides a phone number hotline to call for more information, and often offers 1 year of free credit monitoring. And that's it. even if you get that much. The organization sending these letters hopes that after a quick groan, you will throw the letter in the trash and move on with your day. Indeed, the costs for organizations are lower if fewer people call the hotline or request credit monitoring. So the letters are written to avoid making people feel uneasy or alarmed. Breach notification is now a basic part of the canon for data security law. That lone California law sparked a trend that has launched billions of letters. If there is an undisputed winner in all this, it's the post office. Variations in breach notification laws. Although breach notification laws all have some form of notification in common, the laws are far from uniform, and their approaches have evolved over the years. Breach notification laws differ significantly on how they define a data breach, the type of incident that triggers notification. Generally speaking, most states define a breach either as any unauthorized access to personal information or as acquisition of personal information. Many states adopt some form of a harm requirement along the lines of the CIA security triad, intrusions that compromise the confidentiality, integrity, or availability of personal data. However, enough ambiguity remains in many definitions of a security breach that it is not fully clear if a breach occurs merely when unauthorized people gain access to a data storage system or whether the data must be exposed to significant risk, even if harm has not yet occurred. California's breach law requires that personal data be reasonably believed to have been acquired by an unauthorized party. According to guidance by the California Office of Privacy Protection, factors to demonstrate acquisition of personal data include indications that the data is in the physical possession and control of an unauthorized person, or has been downloaded or copied, or was used by an unauthorized person. Many U.S. states have followed this approach and define a breach as involving the acquisition of personal data. The problem with requiring the acquisition of data is that sometimes unauthorized people look at data yet do not copy it. The goal might have been just to learn information, but many laws do not consider such actions to be a breach. Frequently, all that can be known is that a hacker broke in and improperly accessed the data. Whether the hacker copied it or used it is unknown, nor is it known what the hacker might do in the future. In other words, the hacker could have acquired the data, but it is quite difficult to know for sure. Other notification laws require notification only if there is a misuse of personal data or a reasonable likelihood of misuse. HIPAA's breach notification standard requires notification when there is a risk greater than a low risk that information is compromised. The EU's General Data Protection Regulation, GDPR, requires notification whenever data has been improperly accessed, destroyed, lost, or altered that will result in a risk to the rights and freedoms of natural persons. Another way that notification laws vary is in how they define personal information. Notification is required only for breaches involving personal information. In the U.S., most states define personal information as an individual's first name or first initial and last name in combination with an additional data element, such as a Social Security number, driver's license number, or financial account information with the applicable PIN or access code for same. Recently, however, many states have amended their statutes' definition of personal information to include additional data elements, such as biometric health information, username, email address, and password. In the EU, the GDPR has a broader concept of personal information. Using the term personal data, the GDPR's definition encompasses any information relating to an identified or identifiable natural person. Personal data is identifiable when it is possible to identify people directly or indirectly from the information. The GDPR's definition is much more sensible, compared to the way many U.S. notification laws have defined personal information. There are many instances under U.S. laws where information can be linked to people and can be used to cause them harm, yet don't fall under the statutory definitions of personal information. Once a notification law is triggered by a type of incident affecting personal information, the laws further vary in how quickly they require notification. Many laws mandate notification without delay or as soon as practicable. In the United States, a sizable minority of states, about 40%, have timelines. Florida and Ohio were the first states to mandate a maximum time, 45 days, between the identification of a breach and notification of the affected parties. Both laws were passed in 2005. In 2006, Wisconsin and Colorado set time limits of 45 days and 30 days, respectively. Before 2014, only these 4 states had set time limits. But then, in 2014 and over the next few years, 14 more states added timelines ranging from 15 to 90 days, with most still mandating 45 days. Recently, timelines have been shrinking. The GDPR, for example, requires notification of the authorities within 72 hours after discovering the breach. Notification laws also diverge in who can sue following a violation of the law. In the U.S., 10 states and the District of Columbia explicitly allow for a private right of action in their laws. Most states lack a private right of action. Problems with breach notification laws. Breach notification laws are quite popular. But do they work well? In at least one way, they do. Breach notification laws have added much greater transparency to data breaches. The increased transparency has been tremendously important, shedding much-needed light on the extensiveness of the data breach epidemic and the inadequacy of the data security of many organizations. They also at least provide a reputational incentive to encourage executives to invest some resources into avoiding data breaches. Unfortunately, in many other respects, breach notification falls short. Breach notification laws ultimately do not require good security. They merely require organizations to provide information about data breaches. Inadequate protection of consumers. A main purported goal of breach notification is to help protect consumers, but it is not clear that the laws achieve this purpose. Recall the Target breach that we discussed earlier. Under the law of most states, Target was required to individually notify affected customers. Target sent out a letter from its CEO that stated, in part, Target learned in mid-December that criminals forced their way into our systems and took guest information, including debit and credit card data. Late last week, as part of our ongoing investigation, we learned that additional information, including name, mailing address, phone number, or email address, was also taken. I am writing to make you aware that your name, mailing address, phone number, or email address may have been taken during the intrusion. People are affected by so many breaches, and they receive letters like this all the time. The letters say little to help people assess their risk, and there is often not much people can do except to keep a more watchful eye on their credit, change their passwords, and hope that nothing bad happens to them in the future. People also experience breach notification fatigue. Receiving countless notices becomes tiresome, making some people throw up their hands and think that all is hopeless. People might not respond with as much concern or take protective steps after receiving so many breach notifications. Notification timelines are getting shorter as a way to make laws tougher. The GDPR requires companies to send notifications without undue delay, but not later than 72 hours after becoming aware of the breach. The Federal Deposit Insurance Corporation, FDIC, has proposed a 36-hour time frame, but shorter timelines aren't always beneficial. In the initial days following a breach, not enough is known about the nature, size, and scope of the data breach to report details accurately. Too much attention is placed on how to make the notification and not enough on figuring out what went wrong and how to stop the bleeding. States and countries are racing to create the shortest possible reporting and notification deadlines. Reporting often occurs too soon to provide accurate, meaningful information. Even when people do receive a notice, there often isn't much they can do about the breach. People can change their passwords and keep an eye on their credit card transactions, but they can't change their fingerprints, and Social Security numbers are very difficult to change. Unproductive increase in the costs of a breach. A byproduct of breach notification is that it increases the costs and pain of a breach. Reporting a breach to all the different regulators involved is a cumbersome and complicated task, and it's very expensive. A myriad of different deadlines and requirements must be met, and often in a very short period of time. Notification letters are quite costly to send, especially for large breaches involving tens of millions of people. Breach notification, in essence, works like a strict liability fine, as it involves costs regardless of whether an organization was at fault for a breach. Organizations must pay costs to notify based on the size of the breach, not based on how careless they were. Lawmakers often aim to deter careless conduct by making fault the trigger for liability. The idea is to increase costs for those acting carelessly. Because the costs of notification are not based upon a company's fault, however, notification rules impose the same costs on everyone. Those who have strong security must face the same costs as those who have poor security. This is a lost opportunity to incentivize better data security. Of course, other laws can penalize fault, such as private litigation, but as we will discuss later, this type of law isn't working very well either. When California first conceived of breach notification, few knew the full scope of our data vulnerability. The breach notification law was a critical intervention at the right time, but our understanding of the problem has evolved over time, and so too must our rules. Breach notification provides valuable transparency and some reputational incentives to invest in meaningful data safeguards. But it achieves these goals at a tremendously high expense, siphoning resources and money from other measures to address security. Breach notification is also problematic when policymakers view it as the primary response to data breaches. Breach notification is being asked to do far more than it is capable of. It provides transparency, but it doesn't provide prevention, protection, or a fix. Too much money and resources are spent on notification with not enough being achieved. There are ways to provide transparency at a fraction of the time and cost. For example, lawmakers might remove the requirement for notifying individuals about a data breach in lieu of more robust public disclosure requirements that ensure high visibility of a breach in the media and by regulators. Although breach notification produces light, it also generates a lot of unnecessary heat. Resources could be better allocated to other security measures that would help improve data security. Security safeguards laws. A second type of data security law is what we refer to as security safeguards laws. These types of laws existed long before breach notification laws. They are the workhorse of data security law. Safeguards laws differ from breach notification laws because safeguards laws involve administrative, physical, and technical data security standards. Breach notification is mainly about providing information about data breaches. Security safeguards were incorporated into many of the privacy laws of the 1970s, 1980s, and 1990s. It is important to note that security was often dealt with in privacy laws rather than separate security laws. These days, things have changed, and legislatures often pass independent security laws. The reason why security was included in privacy laws traces back to the original set of fair information practice principles. FIPPs, which have formed the backbone of most data privacy laws. The FIPPs were famously articulated in the 1973 report by the U.S. Department of Health, Education and Welfare, HEW. The report, Records, Computers, and the Rights of Citizens, was an early attempt to address the rights and responsibilities associated with keeping data about individuals. The report recommended the passage of a code of FIPPs, which have been highly influential in shaping countless privacy laws. Among the FIPPs was the following: any organization creating, maintaining, using, or disseminating records of identifiable personal data must assure the reliability of the data for their intended use, and must take reasonable precautions to prevent misuse of the data. Whether included in privacy laws or, later on, in separate security laws, the security safeguards approach to regulating data security aims to require organizations to implement security safeguards to protect personal data. This approach differs significantly from breach notification, which focuses only on providing notice that a data breach has occurred. Security safeguards involve various best practices that organizations should undertake regarding data security. Examples of safeguards include having a chief security officer, having a comprehensive security program, having key policies for security, controlling access to data, encrypting data, backing up data, properly retaining and destroying data, and so on. Types of security safeguards laws. Broadly, there are two approaches to security safeguards laws. One, the standards approach, and two, the reasonableness approach. The standards approach provides a list of particular safeguards that organizations must implement. In contrast, the reasonableness approach broadly mandates reasonable data security safeguards but doesn't specify particular ones. This approach tackles the issues case by case. Over time, though, as reasonableness laws are enforced, specific security measures emerge from the cases. The standards approach. Security laws that use a standards approach specify a series of security safeguards that must be followed. For example, the Homeland Security Act, which included the Federal Information Security Management Act, FISMA, of 2002, adopts this approach. FISMA requires all federal agencies to develop, document, and implement an agency-wide program to provide information security for the information and information systems that support the operations and assets of the agency. The Health Insurance Portability and Accountability Act, HIPAA, regulations in the early 2000s, adopts a hybrid standards approach. The HIPAA privacy rule uses the reasonableness approach, merely stating that administrative, technical, and physical safeguards should be used. But the HIPAA security rule of 2003 uses the standards approach, including a detailed list of 18 administrative, technical, and physical standards, as well as 36 implementation specifications, which indicate more specifically how to comply with a standard. For example, companies must implement technical policies and procedures for electronic information systems that maintain electronic protected health information to allow access only to those persons or software programs that have been granted access rights. States have also enacted data security laws, some of which take a standards approach. The most notable state security law was passed by Massachusetts in 2007, the first state-level safeguards law. The law sets forth a series of various administrative, physical, and technical safeguards, such as maintaining a written information security program, conducting risk assessments, and auditing third-party service providers, among other things. The security laws of Oregon and Nevada also employ a standards approach. The standards approach is only used in a handful of security laws. Lawmakers and rule-making agencies are reluctant to pin down specifics when the state of data security is constantly evolving due to new threats and technologies. By far, the most common approach is the reasonableness approach. The reasonableness approach. Under the reasonableness approach, laws typically require organizations to protect personal data with reasonable or appropriate or adequate safeguards. These words essentially mean the same thing, and they establish a standard that is open-ended and vague. In applying this standard to particular cases, regulators look to common practices. An early example of the reasonableness approach is the Privacy Act of 1974, which requires that federal government agencies establish appropriate administrative, technical, and physical safeguards to ensure the security and confidentiality of records. The Federal Communications Commission, FCC, has adopted a reasonableness approach to enforcing against security violations by companies providing radio, television, phone, and cable services. States have also enacted a number of data security laws, most of which take a reasonableness approach. The most significant and prevalent user of the reasonableness approach is the U.S. Federal Trade Commission, FTC. Since the late 1990s, the FTC has used its broad authority under the FTC Act to bring enforcement actions against companies that have had unreasonable data security. The FTC Act grants the FTC the authority to enforce against companies that engage in a deceptive or unfair trade practice. The FTC's early cases involved claiming deception when a company promised reasonable data security in its privacy policy, yet failed to live up to this promise. A deceptive act or practice is a material representation, omission, or practice that is likely to mislead the consumer acting reasonably in the circumstances, to the consumer's detriment. For example, in 2002, the FTC brought an enforcement action against Eli Lilly, a pharmaceutical company. Eli Lilly manufactured Prozac, a drug used for treating depression. Eli Lilly offered customers a service that would send them email reminders to refill their prescriptions. The company later decided to stop the service, and it sent out an email to notify all subscribers. Unfortunately, Eli Lilly made one of the most basic blunders of email. It put all the individuals in the to line of the message rather than in the BCC line. The result was that all users of this service now knew each other's identity. The FTC faulted Eli Lilly for not living up to its promises to maintain the confidentiality and security of people's personal data, because Eli Lilly failed to adequately train and oversee its employee who sent the email. Later on, beginning with In the Matter of TJX Companies, Inc., in 2008, the FTC began enforcing reasonable security in the absence of any particular promises made by companies. The FTC has claimed that unreasonable security is an unfair trade practice that causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and is not outweighed by countervailing benefits to consumers or competition. Interestingly, in determining which security practices are unreasonable, the FTC has relied heavily upon the National Institute of Standards and Technology, NIST, Special Publication 800-53. This framework consists of a series of standards. Over time, as the FTC has determined that various security practices are unreasonable, it is possible to develop a list of the practices that the FTC has deemed to be reasonable and unreasonable. This list begins to resemble a standards approach. The FTC also enforces the Safeguards Rule of the Gramm-Leach-Bliley Act, G.L.B.A., which requires financial institutions to adopt administrative, technical, and physical safeguards that are appropriate to the institution's size and complexity, the nature and scope of institutional activities, and the sensitivity of any customer information at issue. Although the rule has a few specific requirements, it mostly takes a reasonableness approach. A more recent enforcer of data security to join the party is the Securities and Exchange Commission, SEC, which started to become active in 2014. Instead of issuing a set of security requirements, the SEC has used a reasonableness approach. In 2015, the SEC faulted an investment advisor for failing to adopt written cybersecurity policies and procedures reasonably designed to protect customer records and information. Problems with safeguards laws. Regardless of their approach, safeguards laws have struggled to contain the data security problem. Unhelpful vagueness versus mechanical rigidity. A big debate for safeguards laws consists of the choice between the reasonableness approach and the standards approach. The problem with the reasonableness approach is that many companies find it too vague and lacking in sufficient guidance about what they ought to do. They beg for a checklist so that they can check the boxes and feel assured that they are complying. On the other hand, standards approaches are critiqued for being too rigid. Security threats are evolving, and best practices for security have changed over time, so a rigid list might not keep up with current technology and practice. Lawmakers and policymakers are not always nimble enough and lack the expertise to come up with an up-to-date and comprehensive set of standards. There might be items on a list that don't quite fit specific organizations or contexts. Not all standards approaches fall into this trap. The HIPAA security rules standards are quite broad, allowing for a lot of flexibility in how they are applied by specific organizations. With this balance, a standards approach can avoid the pitfalls of being too vague or too rigid. Unfortunately, standards approaches can fail if organizations undertake a check-the-box compliance strategy. Organizations can check off everything in a list of standards, yet have poor measures to address each standard. Compliance efforts often falter by focusing on quantity rather than quality. As we will discuss later, security isn't just a game of box checking. It's about establishing a careful balance between trade-offs. While industry standards for data security often recognize those trade-offs, there are far too many incentives for companies to implement these standards in a minimal check-the-box manner. Ignoring safeguards. Even when the law requires certain security practices and these practices are really effective, there still is an alarming number of organizations that don't do them. For example, in 2014, the U.S. Department of Health and Human Services began conducting random audits under the HIPAA security rule. The results were awful. 58 out of 59 audited organizations were found to have one or more failures to comply with the security rule. The requirements of many laws, having a comprehensive security program, doing routine security assessments, training the workforce, and so on, are not controversial. They are near universally recognized as worthwhile measures, yet they are often just ignored. Enforcement is too late. A bigger shortcoming of safeguards laws stems from the way they are enforced. The enforcement of safeguards laws is generally triggered by a data breach. The result is that enforcement of these laws mainly adds to the pain of a breach. Breaches are already very costly and painful, so when regulators come along and add a little more to the pain, it often is not a game-changer. This is especially true because the penalties are often far smaller than the overall costs of the breach. The fines imposed on organizations for poor security leading to a data breach are often a slap on the wrist. One article colorfully described the penalty that Australian regulators imposed on Adobe for its 2013 breach of user passwords. The commissioner has flogged Adobe with wet lettuce, telling it to straighten up and fly right to make sure this kind of thing doesn't happen again. Adobe's fine in Australia was $1.3 million, pocket change for a huge company like Adobe. In most cases, fines are often a fraction of the total costs for a breach. Regulatory penalties ultimately raise the costs of a breach by a small percentage, but not enough to make a material difference. Perhaps if costs and pain were ratcheted up even more, then these laws would work better. But costs and pain for breaches have continually risen throughout the years, and the situation isn't improving. As we will discuss later, breaches are the product of many actors, and not 100% the fault of the breached organization. There are limits on what organizations can do to prevent breaches. Enforcing after a breach is often the worst time to bring an enforcement action. Certainly, there should be vigorous enforcement for covering up a breach or lying about a breach, but post-breach enforcement is often an exercise in redundancy. Organizations that suffer breaches are often already engaging in soul-searching and exploring how to improve in the future. Instead, enforcement could be much more effective before breaches occur, prompting organizations to do the kind of rigorous thinking about their security practices at a time when it can help prevent breaches. Additionally, the enforcement of safeguards laws does little to help compensate victims. In 2019, for example, the FTC reached a settlement with Equifax for its breach where victims could be compensated by being paid $125 or receiving 10 years of credit monitoring. People rushed to claim their $125. There was an unfortunate catch, however. The fund to pay victims was only funded with $31 million, and people's payments would be reduced if too many put in claims. The FTC tried to put lipstick on this pig by trying to convince people of the value of the free credit monitoring. Equifax also agreed to pay up to $425 million and possibly more to people harmed by the data breach. But proving harm has long been a challenge, as we will discuss later on. Thus, the typical story with data security enforcement involves regulators collecting some money that is dumped into government treasuries, with barely anything going to consumers. Private litigation. In the years following the Choice Point breach, another body of law bubbled up out of nearly nowhere. Waves of private litigation after nearly every major data breach. Over the past 15 years, there has been an extensive amount of data breach litigation. The rise of data breach lawsuits. Lawsuits usually follow quickly after breaches. For example, in the aftermath of its breach, Target faced 140 lawsuits. One lawsuit was even filed the day after the breach was announced to the public. Target eventually settled the consolidated consumer lawsuits for $10 million. One study of about 230 lawsuits for data security breaches from 2004 to 2014 found more than 86 different causes of actions brought by plaintiffs for essentially the same kind of event. Causes of action involved tort, contract, state statutes, and federal statutes. Problems with private litigation. In theory, the way that data breach litigation is supposed to work is to empower consumers to seek redress for harms from data breaches and to supplement regulatory enforcement with private enforcement in the courts. Thus far, however, private litigation has failed to make a meaningful difference in improving data security. Litigation has increased the costs of data breaches, but has accomplished little else. Cases improperly dismissed for lack of harm. The key issue in data breach cases is harm. Most causes of action that plaintiffs can sue under require what is known as a legally cognizable harm. Even if a defendant acted wrongly, the law often requires a plaintiff to prove that the defendant's actions caused harm. Courts have often struggled to understand the harm from data breaches, so data breach cases have often been dismissed. In federal court, plaintiffs must make an additional preliminary showing of harm to proceed with their case. Plaintiffs must establish standing to be able to sue in federal court. For standing, plaintiffs must demonstrate an injury in fact that is concrete and particularized, and actual or imminent, not conjectural or hypothetical. Data breach plaintiffs argued that the exposure of their data has caused them emotional distress. Many courts, however, are reluctant to recognize harm that consists purely of emotional distress. In the words of one court, emotional distress in the wake of a security breach is insufficient to establish standing. Courts seem so quick to dismiss claims of anxiety over a data breach that they ignore many other areas of law where anxiety alone is recognized as a cognizable harm. Plaintiffs have also alleged that the exposure of their data has subjected them to an increased risk of harm from identity theft, fraud, or other injury. Many courts, however, require harms to be vested, already materialized in the here and now. Additionally, plaintiffs argue that the exposure of their data has resulted in their having to expend time and money to prevent future fraud, such as signing up for credit monitoring, contacting credit reporting agencies, and placing fraud alerts on their accounts, and so on. Courts have been skeptical of these claims, too. A classic example is Riley versus Ceridian Corporation. Riley was an employee of a law firm that was a customer of Ceridian, a payroll processing firm. After an attacker compromised its servers, Ceridian notified its customers that their personal information was affected. Riley and other victims argued that they suffered injuries resulting from an increased risk of identity theft. The court rejected their argument, holding that the harm was too distant because the plaintiffs' conjectures about being victimized by identity theft hadn't yet come true. The plaintiffs' fears were based on entirely speculative future actions of an unknown third party. The court further stated, "Here, no evidence suggests that the data has been or will ever be misused. The present test is actuality, not hypothetical speculations concerning the possibility of future injury." A 2013 Supreme Court case, Clapper v. Amnesty International, USA, has had an enormous influence on data breach cases, even though the case had nothing to do with data breaches. A group of attorneys, journalists, and others contended that the government surveillance violated their constitutional rights. They could not establish that they were definitely under surveillance, but they had a legitimate reason to suspect that they were under surveillance because they represented or spoke to individuals who the government viewed as suspicious. The U.S. Supreme Court held that plaintiffs lacked standing because they could not demonstrate that future surveillance is certainly impending. The court found that the plaintiffs could only speculate as to future surveillance. The plaintiffs also contended that they were injured because they had to take measures to avoid the risk that they were under surveillance. For example, instead of talking to clients on the phone, they had traveled to meet them in person. The court, however, held that plaintiffs cannot manufacture standing by incurring costs in anticipation of non-imminent harm. After Clapper, several courts have used Clapper's reasoning to deny standing to plaintiffs in data breach cases when plaintiffs claim injury due to an increased risk of future harm or expenditures to reduce the risk of future harm. For example, in one case, thieves stole backup tapes with the medical data of more than 4 million service members. The tapes also included Social Security numbers, addresses, birth dates, and phone numbers, along with extensive health information. An employee of a company had put the tapes in his car, an all-too-common blunder. A group of 33 plaintiffs sued. One of the plaintiffs alleged that loans were fraudulently taken out in his name by using his Social Security number, birth date, address, and other data from the tapes. 2 plaintiffs claimed that marketers contacted them by phone and email about their medical conditions. Other plaintiffs alleged other harms. Many plaintiffs argued the exposure of their medical information to an unknown third party was an injury in itself. Several plaintiffs argued that they spent time and money monitoring their credit and bank accounts after the incident. The court took issue with several plaintiffs who argued a risk of future identity theft because the likelihood that any individual plaintiff will suffer harm remains entirely speculative. The court elaborated that whether the plaintiffs will be harmed is entirely dependent on the actions of an unknown third party, namely the thief. At this point, we do not know who she was, how much she knows about computers, or what she has done with the tapes. The court later noted that Unfortunately, there is simply no way to know until either the crook is apprehended or the data is actually used. The problem is that thieves like this are rarely apprehended. Although the court noted that it is reasonable to fear the worst in the wake of such a theft, the court still concluded that plaintiffs thus do not have standing based on risk alone, even if their fears are rational. The court also stated, nor is the cost involved in preventing future harm enough to confer standing, even when such efforts are sensible. There is, after all, nothing unreasonable about monitoring your credit after a data breach. But the court ultimately concluded it was bound by Clapper and could not recognize harm for increased risk for identity theft. Other courts have held that Clapper doesn't foreclose finding harm on these theories. For example, in E.L.V.I.S v. Neiman Marcus Group, the Seventh Circuit held that the plaintiffs could pursue their lawsuit when hackers broke into Neiman Marcus's database. As the court stated, why else would hackers break into an organization's database and steal consumers' private information? Presumably, the purpose of the hack is, sooner or later, to make fraudulent charges or assume those consumers' identities. The story before Clapper was that courts were deeply divided and about whether data breaches caused harm. The story after Clapper didn't change very much. Courts remained divided. In 2016, another Supreme Court case attempted to add more clarity to the issue of standing. In Spokio, Inc. v. Robbins, the court declared that there must be concrete harm for standing, yet it acknowledged that intangible harm, and even the risk of harm, could be sufficient to establish a concrete harm if intangible injury has a close relationship to a harm that has traditionally been regarded as providing a basis for a lawsuit in English or American courts. The Supreme Court, however, failed to elaborate much further. No guidance was provided to distinguish intangible harms that are sufficient for standing from ones that are not. Spokio ended up resolving nothing. After Spokio, the courts have remained divided on the issue of standing. The law is thus deadlocked, with two drastically different resolutions on standing and harm. One of the major challenges in data breach cases is that hackers are rarely caught. Their precise motives might never be known. Personal data can circulate in dark corners for a long time because information, such as dates of birth, mothers' maiden names, and social security numbers, doesn't change. Because there are many breaches, it also becomes difficult to trace a harm to one particular breach. The hackers aren't going to voluntarily step forward and explain where they got their data and what they're going to do with it. Courts that demand that plaintiffs prove harm in this way are demanding the impossible. Failure to help victims. When lawsuits succeed, they rarely do much to compensate victims, even if they occasionally manage to have a small impact deterring future bad behavior. Litigation is mostly resolved via settlement. A study of 230 lawsuits for data security breaches from 2004 to 2014 showed a settlement rate of 50%. The settlement rate during this time was particularly interesting because most cases during this period were being dismissed for lack of harm. Even cases that weren't strong settled for millions of dollars, mainly because of the high costs of litigating a case, even if victorious. The settlements do little to help victims, even if they act as a deterrent for companies. They amount to just cents to a few dollars per victim, and most victims don't receive a penny. For example, Ashley Madison, an online dating service for adulterers, settled with users for $11.2 million for its 2015 breach involving 37 million people's personal data. Anthem, a large health plan, settled for $115 million for a breach involving nearly 80 million records. Just like the safeguards laws and breach notification laws, lawsuits can ratchet up the cost and pain, but often just by a marginal percentage and not enough to be a significant additional deterrent. Lawsuits make a breach feel worse, but they don't do much for consumers. As with the other types of data security law, the problems with private litigation aren't inherent and unfixable. Private litigation has the potential to have a positive impact, but thus far, cases are stuck on the issue of harm, and they are dismissed or settled before they can progress to developing duties and standards. Litigation is focused almost entirely on the organizations that are breached, but these organizations are only partly responsible for the problem. An unhealthy obsession with the breach. After a data breach, the law will spring into action. Breach notification laws will often be triggered, requiring notification of a breach. Regulatory agencies will launch an investigation and might bring an enforcement action. A blizzard of lawsuits will likely be filed. This combination, a triple punch in the gut, is expensive and demanding of resources. That would be okay if the rules and enforcement fostered a secure data ecosystem, but it's not working. Since the Choice Point breach was announced in 2005, there have been two broad trends. First, data breach laws have proliferated. Countless new laws have been passed, and enforcement has increased. Second, data breaches are occurring more frequently and at an increasing size and scale. The same breach-causing mistakes are being made. Even with more data breach laws than ever on the books, we are still setting records for data security failures. One conclusion to draw from the law's failure is that the situation is hopeless. The law can't do much, and we are doomed. But we reach another conclusion, one that is much more hopeful. The law can do a lot to improve data security, but it requires a major shift in focus and approach. Although the law fails for a number of reasons, there is an overarching theme behind the law's failure. Data security law focuses too much on the breach. For example, breach notification laws revolve around the breach. Attorneys file hundreds of lawsuits in the wake of a data breach. The FTC and Department of Health and Human Services, HHS, typically use the data breach as the launching point of their enforcement actions. It was the breach that sparked and fueled so much of the law's development. Unfortunately, the more the law has obsessed over data breaches, the less effective the law becomes in stopping them. As the number, size, and severity of data breaches continues to rise year after year, policymakers are doubling down on this approach to regulating data security. Breach notification laws are proliferating, expanding, and strengthening in numbers. More regulators are pouncing on breaches. Breach lawsuits continue to multiply. Unfortunately, this approach is leading to a dead end. The law must take a new direction. It needs a new focus. Ironically, to reduce data breaches, the law must stop obsessing over them.